Today, we're going to be talking about the South Carolina Residential Landlord Tenant Act. And we're going to be giving kind of a general overview of the topic, speaking about the responsibilities of both the landlord and the tenant. We will have a period at the end where we talk about a couple of frequently asked questions. This presentation is not meant to serve as a substitute for reading the various laws discussed, that law being the Landlord Tenant Act. Not to do this in place of seeking legal counsel or otherwise requesting department guidance or interpretations of the law it administers or enforces. This presentation is merely serving as an introduction and overview of the topic. Phil is an attorney, but he's not going to be able to answer your personal nitty-gritty questions, especially those that you should be asking your own personal attorney. Okay, so I'm going to do a quick intro of Phil Porter. I'm really happy to have him here today. Phil was born in 1953 and he was raised in Pickens, South Carolina. He got his undergraduate degree from Clemson University and finished law school at the University of South Carolina in 1979. When he was at USC, he was a law clerk for us, SCDCA, becoming a staff attorney in 1979. He later served as deputy for regulatory enforcement and also as the administrator and consumer advocate. In 2002, he left the department and entered in private practice. And then he just couldn't get enough of state government, went back in 2007 to be the deputy general counsel for the Department of Motor Vehicles. Now he's back with us. We're so happy that Phil is here as a staff attorney and he knows all the ins and outs of the Landlord Tenant Act, or at least in my mind when he talked about it with us. He seemed like he knew a good deal. So welcome, Phil, and I'm going to turn it over to you so we can get started.
Well, good morning, ladies and gentlemen. I am an attorney. I was at the department many moons ago. I am back. I am also, or at least have been during my life, a tenant a number of times. And I am also, and have been for a while, since the 80s, a landlord myself. And I've probably made most of the mistakes that landlords and tenants make when they enter into leases together. So what we're going to do today is see if we can help you avoid some of those mistakes. We'll be talking about the Residential Landlord Tenant Act. And we'll probably refer to it mostly as just the Act. So we'll I'll not stumble over my tongue more than usual. General provisions of the Act. It's found in South Carolina Code of Laws 27-40-110 et sec. That means as follows. Now, it was enacted in 1986. Before the enactment of that law, the South Carolina law strictly favored landlords. The joke was that tenants' rights were summarized in this statement. The tenant has the right to pay rent. The tenant could not withhold rent even if the landlord did not provide essential services like heat or water or repair dangerous hazards. The Act in 1986 was a great improvement from the tenant's perspective. It applies to rental agreements for dwelling units located in South Carolina, regardless of where the agreement was entered. It does not cover detention facilities, medical, geriatric, educational, or religious facilities, transient occupancy in hotels subject to sales tax, occupancy under contracts for sale, or residence at a charitable or emergency shelter. Leases. Do they have to be in writing? No, they do not necessarily have to be in writing. However, it's usually in the best interest of landlords and tenants to make sure that they have their rights and duties set forth in writing. If there is no writing, it's generally the tenancy is a month-to-month tenancy. Now, what that means is that either party to the contract can give notice this month and say the end of the tenancy is the next month. If the written agreement exists and it isn't signed by both parties, but the rent is paid or accepted, or if the tenant goes into the apartment, then it's the same as if the agreement were signed. Prohibited provisions under the Act are unenforceable, but they do not invalidate the entire lease as a general rule. Landlord obligations. The landlord, of course, must deliver possession of the premises. The landlord must maintain the premises. The landlord must comply with all building codes, must keep the premises in safe and habitable condition, must make available running water and reasonable amounts of hot water and reasonable heat. The landlord must maintain heating, electrical, and plumbing systems. The landlord must maintain appliances that have been provided by the landlord. Note, however, the landlord must make property available with these features and repair as necessary, but has no obligation to pay utilities unless that's agreed to separately in the lease. The landlord and tenant of a single-family residence may agree in writing that the tenant will perform maintenance of the premises, including lawn care, such as mowing the grass in the summer or raking the leaves in the autumn. Some case law interpretations. The main thing to learn from these case law interpretations is that notice and written notice is pretty darn important in the landlord-tenant relationship. That's what about 3 of these cases are about. In Robinson versus Code, there was a problem, actually a fatality in a rental home. It was found to be not actionable under the Act, even though apparently the smoke detectors were non-existent or had failed and the law required them. There was no provision in the Act unless the tenant gave notice that there was a problem with smoke detectors. In Thompson versus CDL Partners, it was held that the landlord had to be given notice of any defect to be liable for failure to make necessary repairs. Again, notice is very important. In Fair versus United States, the parties contested whether fit and habitable duty on the part of the landlord applied to all sorts of conditions. And the court said, well, part of the duty of the tenant is to keep the premises reasonably clean, and it's not the landlord's duty to make sure that those things happen. In Pryor versus Northwest Apartments Limited, the landlord was held not to breach a statutory duty of keeping the premises reasonably safe where the tenant slipped and fell in a muddy common area. The law of negligence had long indicated that if some sort of hazard was obvious, then the owner of the property doesn't necessarily have a duty to warn the owner or the visitors or the tenant of obvious hazards. Tenant obligations. The tenant must also comply with housing codes impacting health and safety. The tenant must keep the premises safe and reasonably clean. The tenant must dispose of garbage in a clean and safe manner. The tenant must use facilities and appliances in a reasonable manner. For example, if by chance the electricity gets cut off and the tenant starts using the oven as a heating source, then that can cause problems with safety and to run down the appliance. The tenant cannot deliberately or negligently destroy or damage premises or personal property included within it. The tenant cannot disturb the peaceful enjoyment of others, including neighbors or fellow tenants, or allow the tenant's visitors to do so. The tenant must comply with reasonable rules and regulations. The tenant must occupy the dwelling solely for the purpose of habitation, and no illegal activities are permitted. Rules and regulations. The landlord may adopt rules and regulations. However, to be enforceable, the rules and regulations must promote the safety of tenants or preserve the property from abuse. They must apply to all tenants in a fair and equal manner. The tenants must be given notice when initially renting or when the rules are adopted by a landlord or a subsequent landlord. If the rules are adopted after the tenant enters into the agreement, the rules must not substantially modify the tenant's obligation for the term of the lease, and the tenant has to be given 30 days notice to object in writing if the tenant believes they are unreasonable. Access to premises. The landlord's agent can enter into the premises without consent under certain circumstances. Anytime in the case of an emergency. Examples are a hurricane is expected and the landlord needs to board windows, or a pipe has burst and is filling the basement or crawl space with water. A landlord can enter between the hours of 9 a.m. and 6 p.m. for regularly scheduled periodic services, such as spraying for insects and so forth, provided that the right to enter is in writing in the agreement and the landlord announces that intent with 24 hours notice. Between the hours of 8 a.m. and 8 p.m. when the landlord is providing services that the tenant has specifically requested and the landlord has given 24 hours notice. The landlord must not abuse the right of access or use it to harass the tenant. The tenant likewise must not unreasonably withhold access. This includes letting the landlord show the premises to prospective buyers or prospective tenants after the lease expires or shortly before the lease expires. The tenant cannot change locks without permission. Now to tenant remedies. The tenant must give a landlord written notice of non-compliance materially affecting health and safety or physical condition of the premises. You will notice in these materials, the term notice and written notice gets mentioned prominently several times. That's why it's important to both landlords and tenants to pay attention to written notice and provide written notice. Examples: broken locks on doors, broken windows, structural damage or water damage, lack of smoke detectors. The courts typically treat a violation of building codes as an implicit violation of the lease by law. The landlord has 14 days to remedy the breach. Note, however, the tenant has no right to withhold rent during the 14-day period. Staying in the apartment almost always means the rent is owed. The tenant can terminate the lease agreement if the landlord does not make repairs within the 14 days. But there is an exception, unless it's for breaches not directly impacting health and safety. For example, maybe a board is loose or something. If the landlord begins to make repairs within the 14 days and completes it within a reasonable time frame after that, then the lease agreement stays in effect. If the agreement is terminated, the landlord has a duty to return the security deposit. Tenants cannot terminate leases if their own actions or those of their family members or guests caused the need for repairs. Tenant's failure to deliver possession. No rent is owed, of course, until the possession is delivered. That's the whole point of a rental. Tenant can terminate the agreement upon at least 5 days written notice, and the landlord must return prepaid rent and security deposit. Or the tenant can demand possession and bring action against the landlord and any person possessing wrongfully. The tenant is entitled to actual damages, and landlords are not liable for damages if they make reasonable efforts to obtain possession. But notice, whenever in these materials it says that the tenant or the landlord may take action, it needs to go to court, so it's not going to automatically happen. Landlord's failure to deliver possession continued. If a failure to deliver possession is willful and not in good faith, the tenant may recover the greater of 2 times monthly rent or 2 times actual damages. In addition, the tenant can also recover reasonable attorney's fees. But as we've noted, this requires going to court to do that. Wrongful failure to provide essential services. What are essential services? Running water, reasonable amounts of hot water, plumbing, sewer access, gas when used for heat, hot water, and cooking, electricity, and heat by any other source. What about air conditioning? It's not mentioned in the Act. If central air or window units are provided when the lease is signed, the landlord would have a duty to maintain those like any other appliance or feature bargained for, but they may not necessarily be considered an essential service. Wrongful failure to provide essential services continued. If a landlord is negligent or willful in failing to provide essential services, the tenant may give written notice to the landlord. Again, written notice. The tenant may procure reasonable amounts of the essential service and deduct that money from the rent. Alternatively, the tenant may recover damages for the diminished market value and attorney's fees, though of course this also means going to court. The tenant's rights do not arise until they have given that written notice to the landlord and the landlord fails to act within a reasonable time. Tenants do not have these rights if their deliberate or negligent actions or omissions cause the problem. The landlord's non-compliance is a defense to an action for eviction. In an eviction based for non-payment, the tenant may use landlord's non-compliance as a defense or counterclaim. This is a limited exception to the general rule that if you stay in the apartment, you must pay rent. However, there's a caution. The tenant must have given written notice to the landlord, and the tenant is considered to have waived the violation if no notice is given. In addition, if the tenant has to go to court, court always has uncertain outcomes. So the decision might go against the tenant too. Fire or casualty damage. If the dwelling unit is damaged or destroyed by fire or casualty to the extent that normal use or occupancy is substantially impaired, then the tenant may immediately vacate the premises and notify the landlord in writing within 7 days of the intent to terminate the rental agreement. The landlord should then return the security deposit and prepaid rent unless fire or casualty was caused by the tenant's negligence or intentional act. Tenant may also vacate any part of the property rendered unusable by the fire or casualty. The tenant's liability for rent is reduced in proportion to the diminished value of the unit. But of course, the amount of the diminished value may itself be a matter of dispute. Remedies for unlawful ouster or exclusion. If landlord ousts or excludes tenant by failing to provide essential services, the tenant may recover the possession or terminate the agreement. The tenant may also recover 3 months' rent or 2 times actual damages, whichever is greater, and attorney's fees. Landlord remedies. If the tenant's breach is due to something other than non-payment of rent, landlord must give written notice of that breach and state that the lease agreement may terminate within 14 days. If the tenant remedies the breach in the time period, or if the tenant cannot remedy the breach within the time period but begins to effectuate the remedy, then the lease still continues. If the tenant's non-compliance affects health and safety and requires repair, the landlord has an option to enter the premises and commence repair and be reimbursed by the tenant rather than terminate the lease. Bear in mind, the failure to maintain health and safety standards that are required by code are basically implicit as a violation of the lease. The landlord may be cited by authorities if the tenant has accumulated garbage or unclean conditions. And if the problem is not remedied and the landlord gets ticketed, then the tenant may be evicted. Non-payment of rent. If the tenant hasn't paid rent when due or within 5 days of the due date, the landlord may terminate the lease agreement by giving the tenant written notice. The notice need only be given once per lease period. In fact, it only needs to be given once, even if there's a holdover beyond the lease period. And it can be, and usually is, included in the lease agreement. And if so, the tenant will be considered automatically on notice. So the tenant should never assume that the landlord cannot terminate until the rent is demanded if the rent is already more than 5 days past due. The statute provides the suggested language for the notice, and as I mentioned, the notice is going to be in most landlord-tenant contracts. Personal property. After an eviction, the landlord can remove the tenant's personal property from the premises under certain circumstances. The landlord must give written notice to the tenant. If the premises are abandoned or rental period is over and the tenant has removed a substantial portion of the tenant's property, or if utilities are voluntarily terminated by the tenant and the personal property remains, then if the fair market value of the remaining property is less than $500, the landlord may freely enter and remove the property. If the fair market value of the remaining property is more than $500, the landlord must go to court through the court ejection process. But the landlord is not liable for underestimating the value of the property unless the estimate is grossly negligent. If needed, the landlord may use force to enter the unit, which, if the unit is abandoned, usually that means breaking locks or windows as necessary. Absence, non-use, or abandonment by the tenant. This is defined as an unexplained absence for 15 days after default of payment. If the tenant voluntarily terminates the utilities and there is an unexplained absence after default, the landlord does not need to wait 15 days. The landlord must make reasonable efforts to rent the property at fair market value. The landlord can't just sit around and expect the tenant to pay, even if the tenant is in default. The tenant has to make reasonable efforts to re-rent the premises. Security deposits. When the tenancy is completed, the tenant needs to give the landlord a written request asking for the return of the security deposit. The tenant must provide the landlord a forwarding address. The landlord then has 30 days to respond. The options are to refund the money or provide an explanation of any money withheld, that is, accrued rent or damages to the premises caused by the tenant. If the landlord fails to respond, the tenant can bring an action for 3 times the amount wrongfully withheld and attorney's fees. Retaliatory conduct is prohibited. The landlord shall not raise rent above the fair market value or decrease essential services or bring an action for possession if the tenant complains to government agencies about the housing code violations. Of course, if it's still within the term of a lease, the landlord is not free to raise the rent anyway, unless there's a default. If the landlord acts in violation of these requirements, the tenant may bring an action for possession. Any landlord who acts in retaliation is liable for damages up to 3 months' rent or 3 times actual damages, whichever is greater. Tenants' rights in foreclosed property. Written leases survived the foreclosure of the owner for so-called federally related mortgage loans. That is, loans that are made by federally insured or guaranteed lenders or lenders that make loans totaling $1 million or more in a year. There are exceptions. If a new buyer intends to live in the home as a primary residence, the tenant gets 90 days to move. Likewise, if the tenancy is month to month, the tenant will get 90 days to move. Magistrates Court. Magistrates have jurisdiction over landlord-tenant matters. So do circuit courts, but the vast majority of landlord-tenant disputes get handled in magistrates courts. Eviction actions have short notice periods. Tenants must request hearings and show up for the hearing if they want to contest the eviction. But there must be some sort of defense. Just coming in and saying, I can't afford the rent anymore is not going to be recognized as a defense in almost every situation. The appeal is to circuit court. Other considerations. Read the lease. The Act sets forth the basic requirements for landlords and tenants, but almost anything that is not specifically required or forbidden by the Act can be a matter of bargaining between the parties. Tenants should not assume that a landlord has obligations not specified in the Act or the lease. Examples: cable and internet are usually the tenant's expense unless the landlord commits to them in writing. Likewise, while the landlord must provide access to essential services such as gas and water, the landlord is not obligated to pay the bills unless it is agreed to in the lease. Other considerations. Counties or cities may have ordinances with requirements in addition to the Act. For example, the City of Columbia has ordinances that require such things as smoke alarms must be in all hallways and used sleeping quarters. For complexes with more than 4 families, the alarms must be hooked to the electrical systems as well as the batteries. Outdoor steps and porchways must have handrails. Outlets near sinks or baths must have ground fault interrupters to avoid electric shocks. Landlords must apply for permits each year and sign statements that various features of the unit are in fit and safe condition. Now for some frequently asked questions. Question: my landlord never gave me a new lease when my year was up. Can I stay in the unit for another year if I want? Answer: probably not. If you want to be sure you can stay for an extended time, you need to ask the landlord for a written lease. Without a written lease, your landlord can choose to give you 30 days notice to vacate. Unless you pay weekly, then the notice may be only for a week. More frequently asked questions. Question: can I break my lease if my landlord sells the place? Answer: it depends. Read the lease. If it allows termination by both parties on sale, it will be binding on the new buyer. You may wish to check with the new owner anyway, as most landlords will be happy enough to have a steady flow of rent, or at least for time. If the lease contains no right to terminate on sale, the law states the buyer's rights are the same as if the buyer was the landlord when the lease was first signed. Therefore, both parties would be obligated to the end of the term. More frequently asked questions. Question: a friend who was shown a model apartment in a complex was assured that the apartment he would be getting was the same thing. When he got the keys, the place was all beat up with worn and stained carpet and the doors that wouldn't close. Can a landlord make you sign a lease without seeing the apartment? Answer: no, but you can short circuit that. There's no law that absolutely requires the landlord to show an apartment. But if a landlord suggests that you rent based on a model, you might ask, you seriously expect me to pay a deposit and plan to move in next week to an apartment I have not seen? In fact, most leases have terms that will allow the landlord to show the apartment, or else tell your friend's story to the landlord and say, that's why you're taking a lot of pictures, to make sure that you get the same features and services. Other resources, and these will be available if you want to check in. South Carolina Legal Services, under certain circumstances and within guidelines that people qualify, may be able to assist people in landlord-tenant disputes in court. Their number is 888-346-5592. Likewise, the Lawyer Referral Service can refer lawyers to people with all sorts of disputes. Their number is 800-868-2284. The Department of Consumer Affairs is available locally in the Columbia area at 803-734-4200 or at www.consumer.sc.gov. Now for your questions.
Okay, I'm back. We do have a few questions, and just to say, all of those numbers and the links that Phil just referred to, if you download the slides, they're all in there. Again, if you can't download them for some reason, just email me. My contact information is at the end. Okay, so we've got 3 questions here. The first question is a crime background check or a background check necessary to look in a tenant as a landlord?
It's discretionary. And there may be laws that affect whether you can discriminate against people for certain offenses. But I don't think there's anything that prevents a landlord from checking into a criminal background.
Okay, and what I will say is, I talk a lot about credit reports, and landlords are looking at those credit reports too. So to see if you've been paying your bills on time. So just that's a little side thing from me. Second question is it appropriate for a landlord to ask about personal details of the tenants?
It depends on whether they relate to the tenancy itself or to the possibility of illegal activities. But other than that, personal relationships and so forth should not be fair game. Certainly, there are people with certain ethical or religious backgrounds who wouldn't want folks engaged in certain activities that are not illegal from renting, but there may be equal opportunity laws or discrimination laws that forbid discrimination on those bases.
And the next question is, how do you deal with tenants, or what should you do with tenants who are in need or considered disabled?
How should a landlord deal with them?
Yeah, I'm assuming that's what the question is, yeah.
Well, you kind of caught me flat-footed on there because I do not know whether private landlords, at least private landlords in smaller, 1 or 2 unit situations, are required to comply with the ADA. I think larger complexes are required to comply with the ADA and make accommodations like from shelf height or ramps to get up to a spot to get into the apartment and so forth. That is also true with a lot of state agencies like our own. But I would really have to research that and get back to the caller to give a more definitive answer.
Okay. And the last question, at least that's right here, right now, is what if I'm a tenant and I've misplaced the lease? The lease was signed in 2020, and the tenant is currently month to month. Would there be a problem trying to get an eviction if they're 2 months past due and that lease has been misplaced?
I'm sorry, I'm confused. Is this appearing to be the tenant asking or the landlord?
Okay. He just clarified. He said, I'm the landlord, and the lease has been misplaced. Yeah, so the last lease was signed in 2020. The tenant's currently month to month. Because it's been misplaced, would that cause a problem trying to get an eviction if they're past due?
Well, if the lease has been misplaced, that still doesn't mean that there's not a landlord-tenant relationship. And if the landlord can prove that X amount of rent has been paid month to month up until the last, say, 2 months, and that the rent is in arrears, then that landlord can give a notice. If the landlord ends up going to evict the tenant, the landlord is going to have to at least answer questions as to the existence of the lease agreement. However, I think what would probably happen is that the judge would say you still have an opportunity and an obligation to pay rent. And if you haven't paid rent, and if the landlord has given you that 14 days notice that we talked about, then you can be evicted. The one thing that the lease is going to provide in most cases is that notice that shows that you don't have to give the notice again.
Okay, and that's the last question that has come in. And just want to thank Phil for being here today with us and going over the Landlord Tenant Act today. And we want to thank everyone for coming.